Good morning. This hearing is called to order. I'd like to ask Representative Torren Ecker to lead us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Well, good morning. Thank you very much for being here this morning. On behalf of the Pennsylvania House Republican Policy Committee, I want to thank everybody for taking the time to be here, our testifiers, our guests, our members. My name is David Rowe. I have the privilege of representing the 85th Legislative District that covers Union, Snyder, and Juniata and Mifflin counties. And before we begin, I would like to allow the members to introduce themselves and the counties they represent. We're going to start here with Representative Flick, work our way down, and then go this way right after.
Thank you, Chairman. I'm Representative Flick. I represent the 83rd District, which is Lycoming and Union County. Thank you.
Good morning, Representative Jill Cooper. I represent the 55th District, which is Westmoreland County. Thank you all for being here.
Good morning, friends. I'm Representative Jonathan Fritz, proudly representing the 111th Legislative District, comprising Wayne and Susquehanna counties.
Representative Clint Owlett. I have all of Tioga County and about half of Bradford County, 68th Legislative District.
Representative Tom Jones. I represent the 98th Legislative District, which is the northwest corner of Lancaster County and the southwest corner of Lebanon County.
Good morning, everybody. Representative Torren Ecker. I represent parts of Adams and Cumberland County.
Good morning, Dane Watrow. I represent portions of Luzerne and Schuylkill counties.
Good morning. I'm Tim Twardzik. I sit next to my good friend, Mr. Watrow, and we share parts of Schuylkill County, and it's great to see everybody this morning.
Good morning. I'm Representative John Schlegel. I represent the 101st Legislative District in the heart of Lebanon County.
Good morning, Joe Diorsi. I represent the 47th Legislative District in York County.
Thank you very much, members, for being here. For the information of all of our attendees, what the Policy Committee's job is, our job is to sort of be the fact-finding arm of the caucus. Our job is to travel the state and solicit stakeholder testimony to hear directly from people who are either experts in their field or constituents who have been directly affected by Pennsylvania laws. So our job today is to talk about exactly that. We're here to talk about Representative Jamie Flick's House Bill 1499 and his broader effort to strengthen Pennsylvania's child custody law. Because at the end of the day, this conversation that we're having today and conversations we're having across the state are about one central principle, and it's about keeping children at the center of every decision. So Representative Flick, with his House Bill 1499, asks a wonderful question, and that's whether we can go further to ensure that when both parents are loving, capable, and safe, that children have the chance to maintain strong and meaningful relationships with both of them. So we have several expert testifiers here today, some of which have traveled quite a distance, so thank you very much for being here. I'd like to start off by introducing our testifiers. Former Pennsylvania State Representative Tony Payton, thank you very much for being here. Welcome back to the building. Teresa Sneed from the National Family Justice. I want to thank Greg Felleman from Felleman, and pronounce that name for me? Saramboli Law. Thank you very much. Thank you for being here. And the Honorable Micah Pence, thank you very much for being here, traveling all the way from the state of Kentucky. For the information of our testifiers, we're going to give you all 3 to 5 minutes to go through your testimony, but really a lot of the substantive content we get comes a lot from the question and answer time. So we're going to have 3 to 5 minutes of testimony, then we're going to have lots of questions from the members. When we get to questions, you are welcome to answer every question. You don't have to answer every question because we want to try to get through as many as we can, but obviously we are here to learn from you. So if you've got something to offer, please jump in. Before we move to our testifiers, I want to thank Representative Flick for demonstrating real conviction, his commitment to this issue. In the years that we've served together, Representative Flick, he's one of those people who is tireless in his efforts. When he understands a problem, he wants to address that problem, and he does not let it go. So Representative Flick, I want to thank you for your commitment to working not just across the aisle, but across the state on an issue that affects ever so many people. So I'm going to start things off as the prime sponsor of House Bill 1499. I'd like to start off with some opening remarks.
Thank you, Chairman. And just a little housekeeping. So after this hearing, which will run from 9 o'clock till 10:30, I will remain in this room, as will the testifiers. Everybody else up here has voting meetings and things to get to, but we'll stay here for another hour. So those of you in the audience that have texted me and talked to me over the last few years, you're going to be heard. So we're going to stick here for an hour, and then at 1:30 we'll have a press conference on the rotunda step. So again, thank you, Chairman, and thank you to my colleagues for being here today. I know you have a busy schedule, and to the former state reps that are in the audience today from both parties across the aisle, thank you. And to the good dads and the good moms and the good grandparents especially that came here today and that are listening online, and those of you that have traveled here today from Arizona, from Texas, from Florida, New York, Missouri, and Alaska and beyond, but most of all, those of you from here in the Commonwealth of Pennsylvania that have struggled with this issue. Thank you so much for being here today. I'm going to stay away from the statistics, some of the other testifiers, and sometimes we get lost in those statistics. So I'm going to do, on behalf of those of you that have contacted me, I'm going to tell you my story, and then we'll get to listen to your story later. So I would say my path to this seat in the House of Representatives is quite different than most of the reps up here and most of the 203 members in the House. Many of them have a background in local government. Maybe they were a township supervisor, a county commissioner like Jonathan Fritz, that moved into this seat, or they took political science in college, or they just had an interest, or they were lawyers and they decided it'd be a better idea to be a lawmaker. Mine's a little different. I grew up on a farm, and I started a small family business. So I don't have a law degree. I don't have a doctor's degree. I don't have a master's degree. I don't have a bachelor's degree. I'm just a hardworking family man who wants what all of you want, and that is the best interest of your kids. So again, thank you for being here. I've never been to a school board meeting before I ran for office. I'd never been to a township meeting. But when this issue affected me, I knew I had to make change. So I'd like to say my battle here today was unique, but after hearing all of your stories over the last few years, some are even worse than my story. So I'd like to just to say I was a good dad. I like to think I was a great dad. I changed diapers. I rocked the kids to bed. I taught them how to read, as did my wife. I coached everything you could imagine for all of my kids: baseball, football, soccer, basketball. I founded and was an Odyssey of the Mind coach for my kids. I was a band parent. I was a volunteer reader in school. I'd go in each year and read to kindergarten kids. I was actually the only father, the only dad that was a grade mother or a grade parent. So I did the jobs of both parents. And I dedicated over 20 years of my time, even before I had kids, in the Big Brother, Big Sister, mentoring tons of kids, and then also in the Fresh Air Fund, if any of you are familiar with that, where you take inner city kids and bring them to the country like we have in Lycoming County. So my whole life, even again before I had kids, was mentoring kids. Like half of all Pennsylvanians and half of folks across the nation, sadly, my marriage ended in divorce. What I encountered at the Court of Common Pleas to me was nothing short of shocking. Basically, my kids were kidnapped, and I see a lot of people shaking their head yes here. Not kidnapped by the things you see on TV, but kidnapped by the court. And then every other weekend, they were dangled in front of me, and I had to do exactly what they told me to do, or they would keep my kids or give them to their mother. So my very first court visit, in a matter of minutes, I was told that I would be an every other weekend dad. In a matter of minutes, no investigation, no due process. It was just hard for me to believe. I then spent what seemed like an eternity fighting to get my kids. I went through 5 attorneys, and I learned how truly evil and how broken the system was. What happened next, I guess I could only describe as being very, very bizarre. The exact same court that told me, really, Mr. Flick, you're not worthy of seeing your kids full-time or half-time or even 30%. They then swore me in, the same court, as a court-appointed special advocate, a CASA. My job then, even though I couldn't get my own kids, was to work for the same court and make sure that foster kids were being treated fairly by their foster parents. So again, I can't have my own kids, but the court needed me to care for other kids. Next, as I said, I'd been in the Fresh Air Fund for a number of years, 2 kids from Brooklyn that had lived with me. Next, the court allowed me in less than 1 day to adopt or become legal guardian to those 2 kids from Brooklyn. Could not be more bizarre, but still could not get 50% or even 30% of time with my kids. So to become a legal guardian and to be a foster parent per se and to care for 4 other kids but not my own, something smelled bad. So at that point, opposing counsel then, as you've all discovered, many of you, she attacked my character, my reputation, and I was treated like a murderer or a rapist with these questions that were asked to me. On multiple occasions, opposing counsel, Christina Dinges from the Dinges and Dinges Law Firm, asked that I be put in prison simply because I would not stop. I would go back time after time, motion after motion, to fight what you all are fighting for, your kids. So what followed then is what many of you have experienced: ex parte communication, false allegations, abuse of discretion, abuse of power, and a complete and utter lack of due process. continuance after continuance after continuance to draw it out, motion after motion, to not only draw time out, but to draw money out of my pocket. All of this in the so-called best interest of the children. The legal abuse by the system eventually led me to have a severe stroke. This was maybe 4 years ago. After months of speech therapy and occupational therapy and physical therapy, and when I was able to walk, I walked into my state rep's office and I said, something needs to be done. Not happy with the answer, I looked him in the eye and said, I'm going to run against you. So by some act of God or whatever, I held on and was elected to this seat, which I could not be more proud of. By the time I got to trial, I'd spent over $100,000. I'd survived a stroke. I was taking care of other kids that were not my own, but that were assigned to me by the courts. I had over a dozen witnesses the day of the trial. Now, typically, I don't know if there's anybody in here who ever made it to trial. The objective of both sides is not to get to trial. Stretch it out, stretch it out, stretch it out. When I talked to my attorney the day of trial, she goes, oh, I've never been to trial. This will be fun. It wasn't fun. So she met with opposing counsel. They went and met with the judge, and she came back to me and said, Jamie, you're not going to get 50-50. The courts are not going to give you 50-50. I had a dozen witnesses. I had my oldest son there. I had teachers there. I had coaches there. I had mentors there. So I'm going to read to you the actual court order. It's only 2 sentences long. And if you listen to nothing else today, listen closely to these 2 sentences, which will tell you it's all about the money. It's not all about the best interest. Let me pause there for a second and say, not every court, not every judge, not every attorney. We have some really, really good ones. So, but what I encountered was not really good. So the court order, again, listen carefully. This is after I had begged for years to get my kids and had paid thousands and thousands, and at no point had any judge or any attorney said, oh, hey, how are the kids doing? No, it was nothing in the best interest. So here's the court order. The parties agree that father shall continue to pay child support to mother as though she has more overnights than father. In the event father seeks a support order based upon the parties having equal overnights, the parties agree father shall no longer have his Thursday overnights, thereby providing mother with the majority of the overnights. Meaning, listen, you wore us down. We're going to give you 50-50, but you're going to keep paying as though you're an absentee dad. That way the court, through Title IV deep funding from Washington, D.C., federal incentives, is going to keep getting their money. Lycoming County makes roughly $1 million a year from this. So the language of this was, again, co-authored by attorney Christina Dinges and signed by her good friend, Judge Eric Linhart. So, Mr. Chairman, I'll finish up with this. My story is just one small story. One of my constituents several months ago, who had been fighting to see his daughter for over 15 years. A good dad does not fight for 15 years to see his kid. He, like me, was ready to give up. Luckily, I did not. He did give up. He took a gun, he put a bullet, he put it to his head, and he shot himself. This has to stop. This insanity has to stop. So House Bill 1499 is just a step in the right direction. Thank you, Mr. Chairman.
Thank you very much, Representative Flake. I want to recognize we have been joined by a couple of members. Thank you, Representative Alec Rincavic, for joining us today. I want to recognize that we also have in the audience, we have some attendees. Former Representative Mike Cabell is with us, as well as Representative Tara Probst from Pike and Monroe counties, correct? Wonderful. And Representative, I think, Mary Jo Daly, Chairman of the Recreation, Tourism, and Economic Development Committee representing Montgomery County, is also here today. We're going to move things right to our testifiers. Tony, you're up.
I got to turn it on. That would work, huh? I'm here today not as a former member or a lobbyist, but as a father who's been through the custody system and experienced both its strength and shortcomings firsthand. When my son was very young, after 2 years of court, I was awarded about 40-ish%, for a couple of years. When my son was young, those were sort of the most fulfilling moments of my life, to be able to care for my young son, to, put him to bed, read him stories, make him breakfast, drop him off at daycare, all of those things. It was very important to me. But as he got sort of older, that time decreased. And, you know, it was great for me to be a real sort of everyday presence in his life. I was there for the small moments that matter, getting ready in the morning, bedtime stories, meals together, little things that make up being a parent. But as he got older, school started, time was reduced to weekends and summers. It was tough to go from being an active, hands-on dad to just a weekend parent. I could see how it affected our connection. And I knew that it wasn't what's best for him. I also learned the hard way how easily the system can be manipulated against one parent, often the father. Back in 2016, when my son was only 4 years old, his mother made several allegations of abuse against me. Every single one of them investigated, found to be unfounded. One accusation in particular stood out, where she claimed that my nephew had beaten my son, which obviously would never happen. But that incident stood out because my nephew was at Disney World at the time when he was with me in Philadelphia. So just out of the realm of possibility. I've been accused of a number of things, but from 2016 through 2023, I fought both in Pennsylvania, New Jersey, and New York. For 7 years, I persisted. Now I have a bit more custody with my son, and we now have more of a regular relationship. But I've seen firsthand how things can be weaponized against a father with just crazy allegations. I mean, there was one point where I was living in Australia, and we would come back after every investigation. I'd fly back from Australia to be in court in New York, and every time, every new court date, there was another allegation. And, you know, after the fifth time, we look at the judge and say, I mean, somebody's got to notice a pattern here, and this is sort of crazy. So that experience sort of shook me. And I just know that there's absolutely something that needs to be done to protect fathers like myself who don't give up fighting. You don't fight for, you know, my son is now 13. You don't fight for 9 years in court because you're a bad dad. You fight because you care, you know what's right. So I want to be very clear, though. Protecting children from abuse is absolutely essential. Any real allegation must be taken seriously, but the system needs to recognize when claims are being made in bad faith, and there should be safeguards to prevent false or manipulative accusations from being used to gain leverage in custody disputes. That's why this bill matters. I thank you, Representative Fick, for putting this forward. I know from my personal experience and many others that I've talked to, going through similar things, that change needs to happen. Thank you.
Thank you very much, Mr. Payton. Ms. Snead.
Hi, thank you very much. Chairman, distinguished members of the committee, and Representative Flick, thank you for the opportunity to testify today. My name is Teresa Snead, and I am the founder of National Family Justice, a nonprofit organization that is dedicated to reforming family law systems nationwide to prioritize children's safety, well-being, and fundamental right to meaningful relationships with both fit parents. This legislation is not about parental rights, it's about children's rights, and the science is unequivocal. Shared parenting is what children need and deserve. By starting from a place of equality for a loving, fit parent, House Bill 1499 doesn't just reform custody, it prevents the downstream tragedies that ripple through our communities, from foster care overload to fractured futures. Pennsylvania's family courts are in crisis, not because of malice, but because of outdated policies that leave children adrift in a sea of uncertainty. According to the National Parents 2025 Shared Parenting Report Card, Pennsylvania earns a D, ranking in the bottom third of states nationwide. Pennsylvania lacks a statutory presumption for shared parenting, no policy language encouraging equal time, and insufficient safeguards against false allegations that weaponize children. This isn't an abstract policy failure. It's a human emergency affecting tens of thousands of Keystone families every year. Consider the numbers. In 2024, Pennsylvania saw approximately 18,000 divorces, legal separations, impacting over 30,000 children under 18. Yet our current best interest standard is untethered to evidence-based defaults. More than 80% of these children end up in sole maternal custody arrangements, seeing their fathers just one day a week and every other weekend. This isn't equality, this is erasure. The fallout, our foster care system is already strained with 15,000 children in and out of home placements. It sees 20% of entries tied to family disruptions from custody battles rather than abuse alone. And the mental health toll, divorce or separated Pennsylvanians face 2.4 times higher suicide risk than married individuals, contributing to roughly 20% of the state's 3,000 plus annual suicides, many linked to the isolation of unequal parenting. For children, the scars run deeper. Adult children of divorce are 14% more likely to attempt suicide, perpetuating cycles of pain. These aren't isolated tragedies. They're systemic symptoms of a model that defaults division, not unity. And lurking beneath it is the Title 4D Federal Child Support Enforcement Program, whose well-intended incentives had morphed into unintended hammers. In Pennsylvania, over $30 billion in arrears statewide. Title 4D's retention of payments disproportionately jails low-income Black and Hispanic parents, 5 times more often than white parents, for non-payment that they can't afford. This isn't justice. This is a poverty trap that severs father-child bonds, driving the foster, driving up foster entries 15 to 20%, affecting families and fueling racial disparities where Black children are twice as likely to enter care. Thank you. Pardon me for just a moment. Over the past 4 decades, more than 60 peer-reviewed studies have consistently demonstrated that children in shared parenting arrangements experience significantly better outcomes than those in sole custody across virtually every measurement of well-being. In 2022, a meta-analysis published in the Journal of Family Psychology examined 33 studies involving more than 2,650 children. The findings were definitive. Children in joint physical custody were better adjusted than those in sole custody on all measures, including general adjustment, family relationships, self-esteem, emotional and behavioral adjustment, and divorce-specific adjustment. Remarkably, children in shared parenting families showed outcomes statistically indistinguishable from children in intact families. Professor Linda Nielsen from Wake Forest University reviewed 60 studies comparing children's outcomes in shared versus sole physical custody families. The results were striking. In 34 studies, shared parenting children had better outcomes on all measures. In 14 studies, equal and some better on others, and in 6 studies, equal across the board. And in 0 studies did they fare worse. These benefits hold even controlling for income and conflict, logistical issues, and logic dictates that when children have both parents, they get double the love and stability, and their resilience soars. This research isn't theoretical, it's transformative. With mental health, shared parenting kids show 30 to 50% lower rates of depression, anxiety, PTSD, and with self-esteem scores that rival intact families. Academically, they boast higher GPAs, and graduation rates are 20% above sole custody peers. And per Norwegian and U.S. longitudinal data. Behaviorally, risky behaviors plummet, smoking is down 40%, drug use 25% less likely, while delinquency drops 35%. Physically, there's fewer stress illnesses, better sleep, stronger immune responses, and dual homes buffer cortisol spikes. Relationally, the bonds with both parents and extended family ensure slashing alienation risks that affect 11 to 15% of divorce cases. That's over 2,000 Pennsylvania children. Real-world success, Kentucky's 2018 presumption/divorce 25% earned 83% public acclaim and cut court filings, saving taxpayers millions. Arkansas, West Virginia, Florida, and Missouri followed. 20 states eye reform, and Pennsylvania joined the vanguard, not the laggards. This is something that is not just very near and dear to my heart, but it's what caused us to found an entire organization, because we hear these stories all over the United States. We get approximately 300 requests for assistance each week from parents not only in Pennsylvania, but the other 49 states. And they all have the same complaints. Their stories may have slightly different details, but the foundation of what their stories are and what they're dealing with, it's all the same. And this can change with shared parenting. This bill is important. Thank you for your time.
Thank you, Ms. Sneed. Mr. Fellerman.
Good morning. My name is Gregory Fellerman from Harveys Lake, Pennsylvania, Luzerne County. I was asked to come here today to share my journey experience with the custody system that began in 2013. My custody journey is over, and I'm done with that part of my life. But let me tell you a little about me, and then I want to share with this panel my experience. I'm a licensed practicing attorney here in the Commonwealth of Pennsylvania. My career began as an assistant district attorney in Luzerne County for 8 years, handling everything from traffic tickets to murder one in the first degree. I was a city solicitor for the city of Wilkes-Barre. I started my own law firm with my long-term friend, Eddie Saramboli. We have a firm called Fellerman Saramboli. It's a successful personal injury firm, which I was a founding and managing partner for the last 25 years. I'm the former president of Northeast Pennsylvania Trial Lawyers Association. I'm a member of the Philadelphia Trial Bar Association. I am a member and board member of PAJ, Pennsylvania Association for Justice. I am also the immediate past president of the Wilkes-Barre JCC. More importantly, I am the proud father of my biological children, Elise, Ava, and Aiden. I have been blessed with a stepdaughter, Carly Rittenhouse, from my second marriage, to my wife, Melanie. This is my blended family. As a young father, I worked very hard to give my children everything I could. I was a soccer coach, a basketball coach, a baseball coach. I was involved in every aspect of their life, and I did everything I could for my children. At home, I changed diapers, I fed the children, I took them to places, picked them up, did everything that most good fathers can do to raise great children, and I am blessed how they turned out. On January 13th, I separated from my ex-wife and began a long and difficult journey of navigating life after marriage. Having Elise, Ava, and Aiden made this task a little more challenging because going from an everyday father, unfortunately, at that time, I knew the courts were going to limit my time, and that was coming soon. I didn't have much experience in the family law, and what I did, I wanted nothing to do with it. So I decided it would be in my best interest to hire a lawyer. And again, I didn't want to represent myself because obviously anybody who represents themselves sometimes can have a fool for the client. So I hired a very capable family law attorney. His name is Brian Cowley. He is highly respected. He's probably one of the best family lawyers in the Commonwealth of Pennsylvania. And I listened to him, and I trusted the system. My first, and then again, my story is a little different than from what I've heard from the other people here today. My first and only custody hearing was set to establish in 2013. I asked, would I be able to get 50-50? And the answer was no. Probably not, but let's go see what the courts have to say. After that short hearing, it was determined and agreed upon that I would get every other weekend, Wednesdays, equal holidays, extra time around their birthdays. Although not presumed, it was what I expected, and it was exactly what I was told I was going to get. So in the beginning, it was okay. I needed to get my new life in order, new house, new routine, that type of stuff. Going through a divorce and separation is not easy, and anybody who's been through the process can tell you that. After some time of getting my legs back underneath me, I was ready to try to see if I could get additional time with my children. I again raised the issue with my counsel, and he said to me that I did not have a strong chance of winning 50-50. I asked why, and he basically told, because that's the way it is. And even if you fight, you probably won't be successful. Now, I'm one who's very, very comfortable in a courtroom, and I love a good fight. But I'm also a very practical attorney. And I didn't want to question my experienced, highly regarded attorney. But I did ask him. I said, Brian, I have a nice house. I specifically built it for the children. We live at Harvey's Lake. I have the ability to come and go from work when I want. I own my own law firm. I have the ability to hire people to help me, no problem. I have no prior criminal convictions, no drug or alcohol issues, no mental health issues. In my opinion, I thought I could handle the situation. My new home life stabilized, and it stabilized when I met my current wife, Melanie, and I was blessed to have a stepdaughter, Carly Rittenhouse. We were a very stable home, good life. My wife is a labor and delivery nurse. She owned her own pharmacy, and she now is a licensed practice attorney. We strove to create a good, stable home life for our family, and we did the best we could do for our blended family. Despite all this, Brian looked me in the face and said, unfortunately, Greg, it's not going to change the outcome. So despite all that, he advised me not to go forward and back into court. I listened, and I let it play out. Not the easiest thing to do for a guy like me. I like to fight. I like to win. But I listened. We accepted the order, never went back to court, and I took the position, this is a long game. I'm going to win. Well, we would have a lifetime together. I believed we'd have a lifetime together with kids, and after 18, we would do everything in our power to make up that time with the kids together and do what we could. No more court orders after 18. During that time of the court order separating from the kids, we did everything we could. We would go to baseball games, school activities, soccer, field hockey, basketball, academic honors, plays. We did it all to get a little extra time so we could see our kids, and then we always made ourselves available. The years went by, the trials and tribulations of a divorce and custody scenario unfolded, but we got through it. My oldest daughter reached 18. She graduated high school in 2017 and went to Penn State. She's now at Temple Dental School. Go Elise. Ava followed suit and graduated in June. She moved to Florida and went to college. Aiden is still in high school at that time. So that ended my custody journey for Elise and Ava, and we started a new beginning, making time up for our adult children. Nothing prevented that. No court orders, just airplane rides, car rides, making the time to see them, and believe me, we did it. Unfortunately for me, there was a major intervening event that changed my outlook. I lost my place, I'm sorry. That changed my outlook was December 11th, and dealing with it, okay. So on December 11th, it changed. On December 11th, my middle daughter, Ava, who was smart, beautiful, full of life, living life as a daughter, was killed by a wrong-way drunk driver in Florida. She was one of 3 people who killed in that accident, and our family was never recovered. I'm sorry. No family should ever have to go through what we endured. The loss, the emptiness, the pain is unimaginable, and it continues every day. At that moment, I realized that this horrific accident took my daughter, and she was gone. Daddy's little girl was gone. After some time and reflection on my life and asking myself why, what could I have done differently, it came to me that this accident not only took Ava, but it extinguished all my dreams of making up that lost time with her. That, I agreed, that this was taken from me. When I go back in time and I think about it, being, trusting the system, allow it. When we were in that courtroom a decade ago in Luzerne County, that custody order that we entered into did have an adverse effect. The long game didn't work out. And the major culprit was my custody order, which is a 65-35 order. So 65 with mom, 35 with me. And again, my story is not about fighting in the courts, the countless dollars of fighting and calling for more time with my children. My story is about trusting the law, trusting the system, believing in the process. That trust and belief was costly. So here's the math. Time away from initial separation in the court order was roughly 7 years and 3 months. The fact that the court order was 65-35 was costly, and here's how it is. It's a 15% differential. What does 15% differential mean? 1.1 years. Time lost with my daughter. 13 months. 56 weeks. 401 days. 9,624 hours. We're going to be here for about an hour and a half. 577, 440 minutes was taken from me with my daughter. Let that sink in. It's gone. Never getting it back. All because this is the way it is. I can tell you, tell the one reason it wasn't is because I was a bad father. I was a good father. I was a damn good father. I still am. I'm sure some of the people listening here have children. Do you think this was a fair outcome? Should this injustice continue here in our great Commonwealth? I'll suggest an answer, and I'll suggest the answer is no. It should not. Change is needed. And I'm not here anybody to tell me, but I'm not here to tell anyone how to change or fix this problem. That is not my area of expertise. There are people here who are very qualified, and they'll do that for you. I'm not an expert in family law, but we need to change to prevent this type of unforeseen injustice from occurring. And maybe it is foreseen. This injustice happens every day, all in the courts of this great Commonwealth, and fathers, unfortunately, are being mistreated and not treated fairly underneath the law. Fathers, like so many others, need to be treated equally under the law. Fathers should not be punished because this is how it's been. Fathers should not have to wait another day. I've heard from many and discussed these issues with judges, attorneys, custody masters. This is what they say to me. Well, it's getting there. We're almost at 50-50. We're getting close. And I tell them, well, that's not good enough. Fathers deserve better. You can do better. The laws need to change. The antiquated custody system is failing. No one should ever have to look back at what happened and think, maybe I should have done more. Maybe I should have fought more. There should be no fighting for good fathers. Fathers deserve equal treatment under the law. I see a lot of elected officials in this room, and some I know quite well. As you reflect on today's testimony, I want you to remember that your vote and your understanding of how this issue affects real people every day and has real world implications. This is not a partisan issue. This is a bipartisan issue that affects every person in the Commonwealth of Pennsylvania. And your action or inaction will have real effects on families throughout the Commonwealth. And as I conclude, I just want this panel to understand that I have only spoken one time publicly about my daughter's death. I take this matter very seriously, and the fact that I've come here to discuss this means a lot. The only time I've ever spoken her name in public in a setting like this is at the sentencing of the defendants who killed her. So I want you to understand that this is a very serious issue, and unfortunately, I come under very, very sad times and terms. I finally want to commend Jamie Flick for all of his hard work and dedication to solving this problem. Remember, tomorrow is promised to no one. God bless Ava. Thank you for your time.
Thank you very much, Mr. Fellerman, for taking the time to share that. I know that was definitely not easy, but it means the world to us that you were willing to share that. Thank you very much. Judge Pence.
Good morning. I'm Judge Micah Pence, and I'm a family court judge in Kentucky. As they stated earlier, in 2018, Kentucky passed the shared parenting law. I became a judge in 2018. So before the shared parenting law, I'd been a practicing family law attorney. And I'll tell you now, we didn't want this law. As lawyers, as a potential judge, we were against it. We were all scared of what was going to happen. Is it going to be good for a child to be bounced back and forth between a home, to be moved back and forth? Is this going to overwhelm us with litigation? Are we going to have so much litigation that we don't know what to do with it? Those were our fears in Kentucky. And I'm not here to tell you what you should do with your laws in Pennsylvania. I'm not a lawmaker. I'm just here to tell you what we've experienced in Kentucky, because I think that there are a lot of misconceptions, and those are misconceptions that I had. And so I wish that I'd had some of the knowledge that I now do when I had started going through the process and having these cases. So in 2000, the U.S. Supreme Court said there is a presumption that a fit parent will act in the best interest of his or her child. It is a fundamental right of parents to direct the care, custody, and control of their children. It is a rebuttable presumption created by the U.S. Supreme Court in 2000. But before we passed the law in 2018, we had something other than a presumption in Kentucky. We had an assumption that the mom was going to get the children and dad was going to have every other weekend and one night a week. That's where we were, and that's what the law had said was best. There was an assumption that that was what was right for children, and any mother who did not get their children or every other weekend and dad getting every other weekend, it was assumed that it was because you weren't a good mom. If dad got 50-50, not only was there was the assumption that it's because you're not a good mom. Not just the stories that you have heard from the fathers that are here today. But the reality is, when you were walking into a court in Kentucky, into any court, there was an assumption that one parent was going to be the primary parent and that the other parent was going to be the every other weekend parent. That the power in the parenting situation would not be the same. Now, I think that if my husband and I were to divorce today, that I would deserve a chance to walk in and say, yes, my husband's the primary parent right now. He's the one who cooks dinner at night. He's the one who gets the calls from school. But I could do that, and I should have an equal chance. But the reality in my home is that we made a decision as parents so that I could take a job as a family court judge that can't leave the bench when the school calls or when my child's sick, that can't always get the child to doctor's appointments, that my husband would take on that role. And that was a decision we made, and he made a job change. So in our house right now, I would have to admit that my husband is the primary parent that does the primary caretaking. But because that's the role right now in our home, that doesn't mean that if we were divorced that I'm not capable of it. I did it for the first 2 years before I took this job. We are both intricate parts of our child's lives. We both have very different perspectives, and we work together to make decisions. But when you think of it as me walking into a courtroom and having to fight to have an equal chance with my child because he's currently the primary caregiver, it gives you a different perspective. Because you're going to assume that because I'm a female and that I'm a family court judge, that I'm a good parent. And that's an assumption that's easy to make. And that was the problem in Kentucky, is that we were making that assumption. And what I have seen now is that without that assumption, there's equal power walking into a courtroom. And eventually what happens is they don't walk into my courtroom. We have had a lot of settled cases. We've had a lot of people that seek marriage counseling instead of getting a divorce. I can tell you right now, I'm a lot more likely to fight for my marriage to work if I know I'm going to lose my children 50% of the time, because I want to have that time with them. So I'm going to fight to make my marriage work. The other thing that I've seen is when we do have those cases that someone is fighting back because equal time sharing is not right, because it's not appropriate for this child, because it's not in their best interest. The language that is used in the courtroom is not the mudslinging I saw before. It oftentimes starts with, they're a good parent, but our child needs this. Our child does not do as well at their house, our child has a mental health issue that means they need to stay at the same place every night. There are reasons that are child-focused reasons when we need to veer from 50-50, as opposed to mom did this 5 years ago and I'm mad at her about it, or dad did this 2 years ago and he's not capable of taking care of the kids. The conversation changes when two parents have equal power, and that's what this has given them. Do I still have the discretion to say 50-50 time sharing is not correct? Absolutely. And there are a lot of times that it's not. Number one, sometimes a parent isn't available to have the child 50% of the time. But what we do there is we maximize the time with a parent, as opposed to a third-party caregiver, as opposed to grandma babysitting, as opposed to, the YMCA or whatever the alternative caregiver might be. We maximize that time with a parent. And that makes a huge difference, because then you're involved in the child's life on a daily basis. And you have to work together. You have to work together to make those agreements like, I can't pick the child up on Tuesday. Can you get them to soccer practice? You have to work together. And it forces parents to do that, and they know that's the expectation. Walking into the courtroom, they know that they are expected to work together before they walk into the doors. They don't have to fight for that. That is the expectation. And I didn't realize how much of an impact that would make when the law changed. Because when the law changed, that made the perception of what is in your child's best interest change. It changed for the community, for everyone to see it as the law says this is what's best for a child to have shared parenting. So this is what I'm supposed to try to do. As to where the assumption had been very different, and you are all very aware of that. There is that assumption there. And I have to admit that I was wrong. I was wrong to be scared of this law. I was wrong to be scared of the litigation. I was wrong to be as worried as I was that this wasn't going to work. But as lawyers and judges, we don't like change. But I'm thankful that Kentucky was on the cutting edge of this. I'm thankful that we now have another trusted adult in a child's life, so that when something does go wrong, so when there is wrongdoing by a step-parent or a third party that has abused this child or attempts to manipulate this child, they're a lot harder to manipulate when they have two strong parents that they know love them and will have their back. And that's one of the biggest realities, is that when children do not have strong bonds with both of their parents, it opens them up for predators of abuse and neglect. And that is something that I have seen a big change in, that we're catching earlier, that we're catching some of the abuse that was happening in the home, whether it be from mom's boyfriend or a step-parent or someone else. We're catching those things because they have someone they can tell, and we're catching them earlier. So our rates of neglect and abuse in Kentucky have been like a yo-yo, because in a way we're getting more reports, which is great. We're able to stop it in different ways. But it's not something to be scared of. And as a member of the bar and a judge, I can't tell you what you should do here. I can only give you my own experiences, and I'm happy to answer any questions that you have about what it's been like. Are there horror stories and bad parents that don't need to have this? Absolutely. Absolutely. But we create laws to prevent bad action. We don't take away the fundamental right of good parents because we know there are bad parents out there. So again, I'm just here to answer your questions. Obviously, I'm not being paid to be here. This is something that both my state, my family, and my staff thought was important enough that I needed to make the journey up here to inform you all about what we were ill-informed, but glad we got to tackle in Kentucky. Thank you.
Thank you very much, Judge Pence. Before we move on to questions from members, and we already have several on the list, I want to recognize that we have been joined by the Republican Chairman of the Judiciary Committee, Representative Rob Kaufman, serving Franklin counties, as well as Representative Michael Stender, representing Northumberland and Montour counties. Welcome. Also, for everyone in attendance today, anybody watching on the live stream, we only obviously can have so many testifiers at the table and so much time, but if you do go on our website, you will find several pages of testimony, not just the written testimony from our testifiers here today, but also written testimony from several constituents across the Commonwealth that Representative Flick's office has compiled, as well as written testimony from the Pennsylvania Bar Association. So all of that is available on our website, and that's just pagoppolicy.com. All of that written testimony is on there, as well as a recording of this live stream if you'd like to go back and rewatch it at any time. We're going to move to member questions now. As I mentioned earlier, you're welcome to answer any question. You don't have to answer every question. Entirely up to you if you'd like to join in, but we are here to learn from you. We're going to start things off with Representative Fritz.
Thank you, Mr. Chairman. And thank you, Representative Jamie Flick, for your dedication and drive to this cause. Been around Harrisburg for a while, and I've done a lot of hearings, and truly very, very moved this morning. I have my good friend in the back, Mike Krupa, and my dear, dear friend here at the testifier table, Attorney Greg Fellerman. And Greg, to hear you tell a story about your daughter, brother, my heart breaks for you. And oftentimes it prompts reflection. Cancer took my father at a fairly young age, and prompts me to appreciate that much more the time that I was able to spend with my father. So that really is near and dear. Teresa, you talked about the mental health component. I think that's something that we really need to hang our hat on here. The impact to that youngster's mental health and suicide being as prevalent as it is. It's just it's a terrible topic, and it's very hard to talk about, but it's something that we do need to focus on here. My question is going to be this, and Representative Flick or one of our testifiers. So, oftentimes I'll have a conversation or stand up in caucus and say, hey, listen, there's 49 other states dealing with this issue. Can we examine some of the states that are doing it right and maybe look to mirror or emulate their law? And I heard the reference to Kentucky, but I know that there's been a number of states since then that have also enacted law. Is there a gold standard out there that we should focus on in Pennsylvania? That's my question.
Yeah, I'll touch on that. Thank you, Rep. And obviously, I want to hear from the other testifiers. 2 years ago in October, I flew to Missouri as they passed their bill. And I think with the start of Kentucky, that we can make incremental changes. And of course, Kentucky can always go back and change the law. The gold standard, how I would answer that, is going to be Pennsylvania. So, thank you.
Friends, that was not a setup, but perfect answer, Representative. Thank you, Mr. Chairman.
Anything to add from our testifiers? Fantastic. We're going to move on. Chairman Kaufman.
Thank you, Mr. Chairman. So I can't see the other end, but I suspect that I'm the longest serving member here in the room today. And barring those issues that are hyper-partisan and political, this is probably the number one issue that I hear from constituents about, friends, folks who are close to me over the years. And it's one that is a critical impact to families here in Pennsylvania. And as I looked around the room this morning as the testifiers, I came in late, but I listened to every moment on my ears on my way to into the Capitol. And when I looked at the audience today, which also I must say I've never seen one quite so robust in a policy hearing, I saw tears from both men and women because this is something that I think has impacted probably every family in some way here in the Commonwealth. The last that I was majority chair of the House Judiciary Committee, we held a hearing on this issue, but admittedly, we did not at that point have such a tireless, effective, and plugged-in advocate as Representative Flick. So While we attempted, as the majority Judiciary Committee, to put an effective hearing together, I must say this was probably the best I've seen. And also having former Rep. Tony Payton, who it's been a long time. It's good to have you here in the Republican caucus room, Tony. But thanks for returning to share your personal story. And each one who has shared today, I think this is an issue that is not going to rest as long as Representative Flick is around here. And I appreciate his advocacy. I don't necessarily have a question because you guys have been extraordinarily effective advocates. But thank you to the chairman of the House Policy Committee for putting this together, and Representative Flick, and especially the advocates who are here testifying and those around the room today. I look forward to seeing this move forward and let Pennsylvania families who have been, hurt already by divorce be able to receive the love of both parents equally here in the Commonwealth of Pennsylvania. So thanks, Chairman.
Thank you, Chairman. Representative Ecker.
Thank you, Chairman, and thank you to my good friend Representative Flick for having this hearing. I got to say, I'm in a very unique position today as somebody who has been a family practitioner and is about to become a judge in the family court of Adams County. This hearing was perfectly timed, Mr. Flick. And this is an issue that, since I've been here, I've struggled with of how I feel about it, and I've had successes, and I can see positives and negatives. But sitting with Representative Flick on this issue has really opened my eyes to having a conversation about it, and really having looking through it through clear glasses. And something that kind of popped into my mind today is that we're only looking at the custody cases that don't get resolved by the parties. There are hundreds of cases every day that get resolved through agreements, and a lot of those agreements are 50-50 custody arrangements, at least in my experience. Those folks seem to work it out. Maybe there's one thing that's hung up on a litigant that has to go to court to resolve one issue that they couldn't agree on. And then you're in a situation where then you're putting it in the hands of the court where you might agree on a 50-50 custody arrangement, but then you get to court and court happens, right? It's a little unpredictable at times. So I think that there's evidence that shared agreements do work, and I think there's opportunity for that. So my question is, and I don't know who can answer this on the panel, probably you, Judge, is, Pennsylvania has a robust best interest factors analysis that they go through to decide. And one of the criticisms that I think that opponents of this say is that, a presumption will diminish those best interest factors. It doesn't allow the court to consider each one of them, because in fact, if you don't consider each one of them, you get appealed, it's coming right back to you. In your experience, Judge Pence, with the 50-50 presumption, how do you think that impacts your ability to do the best interest analysis? I think you mentioned that you have some form of that in Kentucky as well. What are the pros and cons of still being able to evaluate the best interest factors even under a 50-50 presumption?
The best interest factors become what I'm considering if 50-50 is not possible or is not appropriate for this family. So that's how, I start with, yes, we're going to have 50-50 unless we can't, and I look at the best interest factors to determine when it's not appropriate. So I'm first going to presume that both parents are good parents. And so that's where you have to start. And so basically the best interest factors come next, and determining whether or not they're not both appropriate, both willing to work together. And one of the most important factors that we have in Kentucky, I don't know Pennsylvania law, won't pretend to, I just got asked to come here last week. So, but is that is the willingness of a parent to ensure a meaningful relationship with the other parent. And normally, if it gets to me at this point, because my litigation rates have gone a lot, my caseload is so much easier to manage now. But if it gets to me, a lot of times that inability of one parent to work with the other parent or to encourage that meaningful relationship with the other parent is something that I'm seeing as the reason that the 50-50 won't work, is because we've had that bad faith by another parent. So those factors come next. So basically, we're going to assume that the parents are acting in the best interest of their own children first without our interference. We're going to take that they're acting in their best interest first, and then our analysis comes in if there's an allegation that one parent is not. Does that make sense?
Sure, yeah.
So they're utilized probably even more now than they were before. We just have a starting point to go from, as opposed to our starting point being every other weekend and one night a week, which
Sure.
was pretty much what the default was before.
Sure. And, you know, in my experience, I can't speak to everyone's, you know, as a practitioner in Pennsylvania, we, you know, enter interim custody orders. And I think Representative Flick, I think this is kind of where the trap you got in is, you know, you have either a conciliator or in some cases a judge, you know, setting those immediate, you know, custody arrangements. And it's really hard to get off of that. You know, once that's set, then it's set, and it's really hard to deviate from that. So I think in the 50-50 presumption, there might be more scenarios where that is the initial order, and if that works, you know, maybe that's a positive too. So, you know, I see that as an opportunity as well. But in any event, I do have one other question. I'm not sure anyone on the panel can ask it, but my good friend Representative Reichert from Franklin County took something I think that Representative Flick said, dealing with the let me get it up here, sorry. Yeah, Title 4D, the dealing with I guess the support federal. I don't know if anyone can handle that on the panel. I know Representative Flick probably, we can get you to educate maybe just a little bit on that.
Yeah, thank you, Judge Ecker, Representative Ecker, for another couple weeks. I will start by saying I am absolutely no expert whatsoever at Title 4D funding. I was in Washington, D.C. 2 weeks ago with my good friend Mark Ludwig from Missouri. And maybe when we're done here, we'll bring Mark up to the whole audience to explain it. But in effect, it went in half a century ago during the Carter administration with really great intentions. A lot of women worked out of the house. They were homemakers. So the intention, I believe, was to help the courts reimburse the county some funding to help the mother get back on her feet, and also to help the caseworkers, the domestic relation workers, pay 2/3 of that from the Social Security, from the federal, into the counties. And that was meant really just for a small number. And then during the, try to stay bipartisan here, but during the Clinton administration, it was greatly expanded. It didn't mean if the wife made $1 billion a year and the husband made $1 billion, they still went through this Title 4D, and the counties still got an incentive from that money. So that's where we are today. Again, I'm no expert at it, but we are going to bring a couple experts up at 10:30 to speak to the whole audience, and we will get back to you with more details on that. So anybody want to add to that? I know, Judge, you have a little bit of expert on Title 4D, or Teresa? Okay, so we'll get with Robert Garza and Mark Ludwig on that. So, all right, thank you.
And thank you guys for being here. Thank you for sharing your stories, and thank you for your advocacy. Thank you, Mr. Chairman.
Thank you. Representative Cooper.
Good morning. Thank you. Jamie is my suite mate or roommate here in the Capitol. And so when he first proposed this bill and asked me to sign on, I didn't sign on immediately. You know, I had to really think about it. And after him sharing the story and talking to folks, of course, I became a co-sponsor of it and appreciate his tireless effort. And so I want to thank all the testifiers for being here. And so one of the questions that I get a lot is from women who may say, you know, that their concern is if they have been the caregiver, and I think, Judge, you alluded to this, and they can't, you know, feel like they can adequately hire a lawyer to represent them as well. And, you know, their concern is losing 50-50, or where they think that they're, you know, they're going to be a better parent for whatever reason. And so if anybody on the panel can, you know, just talk about that, because most women feel they're the better caregiver. There may be a disadvantage here with this law. And so I walk through a lot of those conversations with people and, you know, talk about how important it is to have both parents engaged and involved. But I just wonder, in your experiences, you know, what would you say to somebody who's watching this right now, whereas I really don't think I want to give that up here in Pennsylvania. So if you could address that, I'd appreciate it.
Of course, as a mom, I don't want to give up that time. I mean, but that's me being selfish as a mom. That's it. I mean, I'm a parent. I don't want to give up a single minute, hour, or time with my child. And as moms, we haven't had to before. And I mean, I think that it speaks for itself. Of course, we don't want to give up that time, but is that what's right, fair, or constitutional? Both parents have a constitutional right to parent, not just one. And I know it's hard. And I think one of the biggest complaints that hits home with me is, but he's never done it before. I've always changed a diaper. He's never given a bath. He's never done any of those things, and we hear that a lot. As a judge, what I say is, but I'm going to give him the chance, and he'll either show that he can or he'll show that he can't. And that's normally where our temporary arrangements start, is in that 50-50, and then the parent is either going to show that they can carry their weight and do the parenting and be that equal shared parent, or they'll show that they can't do it and can't handle it. And that's where we go into our best interest factors and make adjustments. Having those temporary orders that are 50-50 really, truly show us a lot. We see if it's gonna work or if it's not, which is great to have that insight before I make a final decision. But that's what they get a chance too. And speaking to the lawyers that practice in my court daily and practice family law, they've said it's changed. It's taken women some time, and there's a lot of anger towards losing that time with their children. But there's the other side of that before it's been the father spending the money to fight, as opposed to this coming in at an equal time. So, but now they'll tell me that women come in and they're like, I know I'm gonna have to do this, but I don't want to. And dealing with, but what don't you like about it? So how do we change that? And then you have the chance to make adjustments to your schedules, right? So if you want to maximize that time and dad's working on Tuesdays and Thursdays, well, then change your schedule so that you can have the kids on Tuesdays and Thursdays. That's what we do when we're in a married relationship and parenting our children. We make the changes so that we can maximize that time with the children. And I think this forces that, whether we like it or not.
And statistically speaking, women that share custody with their partner are higher earners, and they have higher life satisfaction because they're not doing it all by themselves. They've got that support, and yes, there's going to be resistance because, like Judge Pence said, as mothers, just like as fathers, we don't want to give up that time with our children, but we chose these people. We had children with these people, and they'll learn how to do the things that we do, and vice versa. But giving women the opportunity to have a little bit of a break, like I said, statistically, they're higher earners and they have higher life satisfaction. And by pushing a father out of a child's life, you are subjecting them to every disadvantage you possibly can. You know, statistically, they're at risk of, drug abuse, high school dropout, teen pregnancy, becoming incarcerated, and the list goes on and on. So this is not just beneficial for fathers, it's beneficial for mothers, it's beneficial for the children. And as a parent, would I like it initially? No, but it's not about me, it's about what's best for my children.
Thank you.
Along those same lines, my situation was a bit unique, as I was never married to my son's, to Jeremiah's mother. So he wasn't able, or he hasn't done it, was used as sort of a weapon against me because the access was denied because of, the non-marital situation.
Thank you. I think everyone in this room knows themselves that they want the love of both parents, right? We all do. And I just can't thank Representative Flick, my good friend, for bringing this bill to Pennsylvania, and I hope this spurs the change that's needed.
Thank you, Representative Cooper. Representative Watro.
Thank you. Representative Flick, thank you so much for championing this and trying to see this through. To the good Chairman Rowe, thank you. You have so many members at you to hold policy hearings, and you decided that this is one to hold. So I thank you for your great interest in this. I'm a guy of very few words, but what makes me sick is that it's sounding like a lot of this is pertaining to money, and that's sickening. I don't come from a family with wealth. Work hard, you earn it, and you go get it. Attorney Fellerman, I know that man from quite a few years. Never heard that story come from his lips. That leads me into about a decade and a half ago. I was blessed and fortunate to get custody of my 2 girls. And I was able to raise them. But I understood how important it was to have Mom involved in their life. Mom was transient. Okay, from Pennsylvania, northeastern Pennsylvania. I would drive my 2 girls to Virginia so they could have that quality time. And then Mom goes off to Texas and very absent. But I could see the decline of my 2 girls without Mom in the picture. The fortunate thing that happened to me, I met a wonderful woman. Her name's Angela. And she treated those 2 girls like they were her own. And where I'm going with this, the time that was missed that Attorney Fellerman spoke about down to the minutes, the hours, is so important. Having a mother figure and the father figure in a child's life is super important. So when you have 2 quality parents, it means everything to have that child develop in so many different ways. The question that I have, and not in my case, obviously, but it seems to appear that courts favor mothers more in a custody situation than a father. And it just might be the limited exposure that I see, but could anybody answer why that is when there is a fit father that's in the picture?
So that would be the tender years doctrine. Typically, and do you remember what year that started?
It was shut down a long time ago.
So typically they believed and that, you know, the mothers were the ones that were raising the children, they gave birth to the children, they nursed the children. So in those tender years, they needed to be with their mother at all times, or at least most of the time. But in years since, there's been a lot of studies that even with infants benefit from shared parenting as well. And so they've moved away from the tender years doctrine. We still have some old judges across the United States that just automatically think that the moms are going to be the better parent. They're the more nurturing. You know, men are typically the providers back when this was set up. And the mothers were the stay-at-home parents, and they were the nurturers. And society's made a lot of changes. We've got a lot of guys staying at home now. We've got a lot of women in very powerful positions in the workforce. So there needed to be that shift, but the tender years doctrine is where it started, and a lot of people are having trouble deviating from that. And then you've also got the domestic violence organizations. They're going to tell you that, you know, placing a child with a father puts them at risk of, you know, abuse, various different types of abuse, and that statistically is not true either. There's a lot of misinformation going on out there. And we really try to make sure our organization, we partner with a lot of other organizations too, that try to make sure that we can get some CLE courses out there for judges and attorneys to see scientifically what the best interest of the children really is, as far as they need both parents. Mothers and fathers each teach their child something different. And like I said earlier, if you take a child out of, or take a father out of a child's life, or severely limit the time that they have with them, they're at every statistical disadvantage that you can think of. And they're missing those key lessons. And we're biologically designed for attachment. And so when you take a parent out of a child's life, sometimes you're creating attachment trauma. And a lot of people just don't realize that. It's just an assumption, like Judge Pence was saying earlier. We've got a lot of assumptions as to what's best.
The tender years doctrine, which assumed that a mother was the most important in a child's life, in the beginning was struck down, just from what I'm looking at, from the local bar, from the Pennsylvania Bar Association, was struck down here in 1997. And so the case that I quoted was Troxel versus Granville in 2007 from the U.S. Supreme Court that made the presumption that both parents are fit and proper parents. So since then, what we've had is the laws in states haven't changed that much. They've just left it to the best interest factors, but not made anything that started things where both parents are equal. We just assume, I don't know what, again, those assumptions have just been left, not realizing that society still doesn't know that there was a change in the law because that's case law, not statutory change. So you had society still acting in one manner while the laws had changed through case law, not through actual statutory change. So I think that makes a difference.
Yeah, I sincerely appreciate everybody that came here today to support Representative Flick and Chairman Rowe. Thank you very much. And just in closing, I would have been devastated if I would have lost those hours, those minutes, those days with my children. So I appreciate y'all for being here.
Thank you, Representative Watrow. Representative Rinkiewicz.
Thank you, Mr. Chairman, and thank you, Representative Flick. In my short 3 years in this building, this is the most challenging hearing I have ever sat through. I'm not a father. I'm probably old enough to be most of your children at 24 years old. But Representative Flick, you managed to fill a room not just with people, but with emotion. And as I look around this room and I see every person in attendance shaking their head and nodding at the stories that are being told and the questions that are being asked, to Tony, Teresa, Greg, and Micah, all I want to say is, and to everyone else in this room who has been robbed by a system we were supposed to believe in, I just want to say that you are being listened to, you are being heard, and I can't wait to vote for this bill one day.
Thank you, Representative Rinkiewicz. I want to mention we have been joined as well by Representative Robert Ledbetter, representing Columbia County. Representative Schlegel.
Thank you, Mr. Chair. This is truly a very emotional and important topic. And I just want to walk down memory lane. It wasn't that long ago when there was a bill that did pass the House this year. It was a bill that was proposed that would take those 16 domains, those factors that judges could use, not necessarily have to, but could use in order to determine the percentage of custody. Now, Representative Flick took his bill and that opportunity to attach an amendment that would call for the presumption of 50-50 joint custody. After Representative Flick spoke to that amendment, I joined him. I joined him because as a parent of a son that went through this, but more importantly, a process that began when my granddaughter was 4 years old, I thought it was so very important to share that story. And I'll summarize it today because basically what I shared on the House floor was, you know, as contentious as divorces are and as and custody proceedings can be, it's very emotional. I said, but the bottom line was the divorce was going to happen. That was difficult enough for my granddaughter to experience that. But to have to go through talking to a judge, talking to folks from Children and Youth, to the police relative to PFA accusations. What consternation did that cause a 4-year-old? It didn't stop at 4. It went to when she was 5, 6, and so on. She's now 13 years old. My son now does have 50-50 joint primary physical custody, and she seems to be doing very well in the first marking period of 8th grade. She earns honor roll status. So we're grateful for all that. But my final comment on the House floor that particular day is this is the right thing to do. Moreover, with that domain bill attached with this particular amendment, I think we would have had the opportunity to take the first step towards righting a wrong, righting a situation that is exclusive of gender, but certainly taking in consideration what's best interest of children. And it just seems to me that we would save parents who are going through the divorce and the custody arrangement. It would save them time. It would save them money. Also save the courts time as well. And we could better use our judges' time to be presiding over cases in which we really need that professionalism from our judiciary. So I fully support House Bill 1499. I actually, last session, had a proposal of my own that was very similar. And I kiddingly shared with Representative Flick, whichever bill gets across the finish line is fine with me. I said, besides, Jamie, in Lebanon County, nobody knows who Representative Flick is, so I'll take credit for it. So thank you, Mr. Chairman.
Thank you very much, Representative Schlegel. I want to thank all of our testifiers, all of our members for being here today. Your expertise and willingness to share with us is invaluable through the legislative process, so I want to thank you again. Obviously, Representative Flick, thank you very much for your leadership on the issue. I'd like to kick it to you for some closing remarks.
Thank you. First, I want to say to Representative Schlegel, thank you for the dozens of you that are here today from Lebanon County to meet with me. Really appreciate you coming. In all seriousness, for the entire shared parenting community and those of you, as I opened with, that have flown from every corner of the United States on your own dime, and for the 4 testifiers today, same thing, on your own dime for coming here. I guess I'll close with this. I'm still battling, right? We're all still battling. You still have the scars. 4 or 5 weeks ago, I was meeting with a state trooper going through similar issues in Philadelphia. I was coming home through the Lehigh Tunnel and I had a seizure and got through the tunnel, woke up and had lost all the vision in my left eye. So I had my chief of staff come get me. And then the next morning I'm in surgery. And I said, oh my God, Carrie, you need to call. I'm supposed to be in court today. I am supposed to be in court. Call the court and let them know I'm having emergency surgery to save my vision. So we filed a motion for a continuance. That motion was denied. So you just can't win. Once you fight the court, it's hard to win. So we have to do it legislatively. But I will say on behalf of all of you here today in shared parenting, we could lose our sight, we could be totally blind, but we will never lose our vision. So thank you all for being here today.
Well, thank you guys once again. I think that custody cases are definitely, as we saw today, some of the most difficult and emotional situations that families face. The laws that we write here in this building have real consequences for children, parents, and the courts that serve them. I think that the consensus is clear that children thrive when systems are centered on their best interests. So I'm hoping that today's discussion will help ensure Pennsylvania's custody laws reflect common sense, lived experience, and what we know is healthiest for children. And let me say a specific thank you to all of you for being here today, for being advocates for this issue. You are how the legislative process works. For me, I don't have kids of my own yet, so this was not an issue that was much on my radar. I just knew that it was a subject of passion for Representative Flick until a young father came to my district office, told me a story that sounded very similar to the ones heard today. And I said, hey, I think I know a guy who cares a lot about that issue. So we connected him with Representative Flick. So I want to thank all of you for being here. Brandon, if you are watching, thank you for coming to my office to share your story with me. I want to thank you all for being here. And just as a reminder, while this hearing is formally concluding, please feel free to stick around. Representative Flick will be hosting a roundtable directly at the conclusion of this hearing. Thank you very much. This hearing is adjourned.